Mr. Ellis, where did you go to school, undergraduate school?
Well, I never finished talking about my background. Am I able to do that?
You need to answer the question that you're asked.
I went to the University of Pennsylvania.
And where did you go to law school?
I went to law school at the University of Texas at Austin.
Were you involved in politics there?
Yes, I was student body president at the University of Texas at Austin.
When you graduated from University of Texas, did you stay in Texas or did you move to another state to practice law?
No, I graduated from law school in 1985, and then from there I moved to Atlanta, Georgia, and I've been in the Atlanta metro area since that time.
When you first moved to Atlanta, were you involved did you join a law firm or were you involved in some other activity for employment?
Yeah, no, I was recruited to come to Atlanta. I really either wanted to go back to Washington, D.C., my hometown, or move to Atlanta. I was fortunate enough to be recruited by a law firm here in Atlanta. And so I moved to Atlanta in 1985. I took the bar exam and I began employment just maybe a couple days after taking the bar exam at that time. And I've been employed with various different law firms, including my own law practice, since 1985 until I was elected CEO in the year 2008.
In addition to practicing law in private practice, were you involved in any other way in the legal profession, in the academic arena?
Yeah, I taught for many years at the Georgia State University College of Law. I taught courses in.
At this point, I'm going to project it. Again, I don't really know where this is going. He's kind of introduced himself, but we're getting way down on the third page of his CV at this point.
We're not 30 pages, we're 3 lines down on CV. This is just background information on him. I'd like to have the discretion to go forward with this.
We know he's a lawyer now. He's talking about where he taught law and.
Did, at some point in time, Mr. Ellis, did you get involved in politics?
Yeah, I was always been actually politically engaged since I was a child. As I mentioned, my parents were in public service, and so when I'm
at a point in time when you were in Atlanta, did you become involved in public service? Did you become a part of any political party or?
Sure, I was active in the Democratic Party of DeKalb County. I was the vice president of the Democratic Party of DeKalb.
Again, I'm sorry, I don't want to do this in front of the jury. So.
Now, isn't it correct that you know, yes or no, that you were involved in, you know, in various political organization campaigns, correct?
Yes, that is correct.
And at some point in time, did you, after being involved in political campaigns, did you decide that you yourself would run for political office?
Yes, in the year 2000, after having been active in political organizations and political campaigns, I decided to run for the DeKalb County Board of Commissioners.
Now, again, at that time, did you meet, right around that time, did you meet Mrs. Ellis?
Yeah, we campaigned together, in fact. Yeah, no, well, let me back up. I met her years before. I began dating her around that time.
Now, you were on the Board of Commissions, the DeKalb Board of Commissioners, for how long?
For 8 years, 2 terms.
How many Board of Commissioners are there?
There are 7 members of the Board of Commissioners. The Board of Commissioners, of course, is the legislative body of DeKalb County government. So I was one of the 7 commissioners representing Commission District 4, which includes an area that runs pretty much from Avondale Estates all the way out to Stone Mountain.
Is there such a thing as a presiding officer?
Yes, the presiding officer is essentially the chair of the Board of Commissioners. He or she is elected by his or her peers every year. In January of every year, the Board of Commissioners takes up an election to elect the presiding officer. That person is charged with the administration of the commission, if you will. And that person chairs the commission meetings at that time in the absence of the CEO.
Were you ever the presiding officer of the Board of Commissioners?
Yeah, I was honored to be elected deputy presiding officer for 1 year and then presiding officer for 5 consecutive years, and which is a record which I believe still stands to this day.
Now, when you're on the Board of Commissioners, was that a full-time job or was that a part-time job?
No, absolutely not. The Board of Commissioners is a part-time job. The Board of Commissioners is a part-time policy-making body by law. And so they receive a part-time salary. They are not expected to be at the office on a 40-hour week or longer basis. Primarily, we meet every other Tuesday in official meetings, and then we'd have committee meetings on the off Tuesdays. And when I wasn't doing that, I was practicing law. It is a tremendous balancing act.
Now, the position of the DeKalb CEO, is that a part-time job or a full-time job?
No, by law, the DeKalb County CEO is a full-time elected position, and you can have no other employment while you're serving in the office of CEO.
When you, we'll strike that, did you at some point in time decide to run for the position of CEO?
Yeah, you know, I thought about it while I was a commissioner. People would ask me to run. I considered running. I ultimately did decide to run for CEO in the year 2008. Had a lengthy discussion, or discussions, I should say, with my wife at the time, because it wasn't an easy decision to make. I had to give up what I had been doing for 24 years prior to that. That was practice law. Had to take a serious reduction in my salary in order to run for CEO.
Objection. Maybe I didn't see it loud enough. Relevance as to what he had to give up and all these other things.
It is relevant, Your Honor, because he's running for CEO to gets elected, and he gives up
I
dramatically.
understand what the answer was. It's not relevant, okay? Mr. Ellis, you need to make sure that you're being responsive to the question that's asked.
Your Honor, yes, I understand. I thought I was being...
Sir, wait for the next question.
Okay. And can I ask a question for clarification?
No.
Okay.
Now, when you ran for CEO, how did you go about raising money?
Well, I had been on the Board of Commissioners for a number of years and had built a network of friends. Obviously, I
Well, did you win in '08?
Yes, I did.
And after the election, was there debt?
Yes. Yes, we did have a debt in '08, yes.
And how did you go about paying off the debt that you had in '08?
Well, it's typical in a campaign that once the campaign is over that you...
To object, if he can testify as to it's non-responsive, he asks, how did you go about, and now he's talking about what's typical in a campaign. And, you know, I wouldn't be, you know, doing the objection bunny thing, but every time I wait to hear the response, it's something that he shouldn't be saying is prejudicial. And so if Mr. Ellis wants to testify as to how he went about, you know, paying back the debt, I have no issue with that. But what the general practice is and what other individuals will do, then I'm going to object to that every time.
Well, let's drill down to what you did.
Okay.
What did you do to pay off your campaign debt?
I continued to do what I had been doing to raise money all along. I raised money by asking people to continue to contribute to hold fundraisers for me until we had raised enough money to pay off all of our debt.
And did you get that debt paid off?
Yeah, we got it paid off. It was after the 2008 election. I seem to recall that it was paid off somewhere around the end of 2009, I believe. That's my best recollection.
Now, in terms of your duties as CEO,
Yes.
in a very general way, could you generally describe your duties as a CEO?
The chief executive officer has a responsibility to supervise, direct, and control the administration of county government. That means that he or she sets the budget for the entirety of county government, appoints a number of different department heads in county government, runs the day-to-day operations of county government, is the face of the county government with regard to intergovernmental matters, has the responsibility to investigate issues that come to his or her attention related to county government. It's a broad and vast executive job.
In particular, now we've had testimony about this, but just for the record, what does RFP mean?
RFP is a request for proposal. It is a term that is used by our purchasing department and many purchasing departments when they're seeking services that they desire to put out for bid.
Now, the purchasing department, let's talk a little bit about that. Is the purchasing department or the P&C department an area of government that you would supervise as CEO?
Yes, P&C stands for Purchasing and Contracting. It is one of the departments that that the CEO has supervisory responsibility over.
Is it necessary to even have a director of P&C?
It's not required to have a director of P&C. The CEO is ultimately responsible for purchasing and contracting. The CEO has the responsibility for setting the rules, establishing the rules for the purchasing department.
Yeah, at this juncture, giving counsel broad latitude without objection, but I feel like at this point we're just importing that ruled upon and forbidden document into this trial. And I don't want to say the name in front of the jury, but you know, I've read it and it's kind of word for word, and that's what we're doing. And it's been going on for the last 5 minutes. So my objection is as to relevance. And all this goes to something that the court has already ruled on as irrelevant.
May I respond? The relevance is that Mr. Ellis, as the CEO, could handle all the RFPs himself if he so chose, but he chose to delegate in a way that was more in giving authority to other people rather than trying to bring it to himself.
Sustain your objection.
Would you be involved, Mr. Ellis, in signing contracts that that the county would have with vendors?
Yes, the CEO signs contracts. The CEO has the authority to sign all contracts. I delegated some of that authority to my chief operating officer, but all contracts over a certain limit, that limit changed from time to time. Initially, I would sign all contracts when I became CEO. That became, there's a lot of contracts that come across the CEO's desk, and so I decided at some point to only sign contracts over a certain dollar amount. And the chief operating officer would sign all of the others.
We've heard testimony about evaluation committee, correct?
Yes.
When a recommendation would come out of the evaluation committee to the CEO's office, what options are available to the CEO to handle the recommendation on the RFP?
Well, the CEO is responsible for putting together evaluation committees. Sometimes they're referred to as selection committees. So I just want to make sure that it's understood that that is the committee that would evaluate an RFP. They would make their recommendation to the purchasing director. The purchasing director had then the responsibility to bring that recommendation to the CEO. The CEO can then do one of a few things. He or she can send the recommendation to the Board of Commissioners.
Relevance. Again, this is not a trial on other crimes that go to how we handle evaluation committees. He's charged with extortion, criminal intent to commit extortion, theft of services. I haven't heard any nexus between these questions the last 10 minutes and what's in this indictment.
Go ahead.
I'm sorry, may I respond or?
Go ahead.
The process by which the CEO has discretion is the point we're trying to make, that there are RFPs that he can say, if he wanted to control the situation, he could say, well, I'm sending this back, or I'm sending it on to the board, and then ultimately he signs the contract. I'm trying to establish what his role is and function in the whole purchasing process, which happens to be at the very heart of this case.
Okay. And I have no problem with you doing that, as we had already discussed. But the problem is that the answers are non-responsive to the question that you're asking. So that's why I've already indicated that if you need to direct the questions a little bit better, that's what you need to do. Because what's happening is that the answer is not responsive to the question.
Isn't it correct that the CEO could then either, when you get the recommendation, you can either cancel the RFP and send it back again, or forward it on to the board for consideration and voting?
Yes, it is correct that once the evaluation committee makes a recommendation and is received by the CEO can either cancel that RFP altogether or send that recommendation on to the Board of Commissioners.
I want to talk to you a little bit about your responsibilities as it relates to, for example, the county attorney. What role, if any, do you have in supervising or appointing the county attorney?
The CEO both appoints and supervises the county attorney. The county attorney is appointed by the CEO. The county attorney has to be confirmed by a vote of the Board of Commissioners and can be removed. The person reports both to the CEO and to the Board of Commissioners. So it's what we call a dual report. 5 out of the 7 commissioners can remove the county attorney, or the CEO alone can remove the county attorney. In other words, the county attorney serves at the pleasure of 5 commissioners or the 1 CEO.
What about the other department heads? What role, if any, does the CEO have in terms of making appointments for the department heads?
The CEO appoints all of the department heads. Some of them are subject to confirmation by the Board of Commissioners, such as the county attorney and the executive assistant, also known as the chief operating officer. A few others, the planning director is subject to confirmation by the Board of Commissioners. The human resources director is subject to confirmation by the Board of Commissioners. But even after confirmed, all of those positions, other than the county attorney and the chief operating officer, serve at the pleasure of the CEO. What does that mean? That means they can be removed by the CEO. And the one exception to that may be the finance director. I seem to recall there's something about that, the chief finance officer.
Now, is it accurate to say that in your administration, you choose to try to delegate more power down to the professionals in the user departments?
Yeah, absolutely. We created deputy chief operating officers, and the way I manage is I hire professionals, and I expect those professionals to be knowledgeable in their subject matter. Obviously, I want them to weigh in and to share their input with me, and but you know, I expect them to do their jobs. Yes.
Now, when you came on as the CEO in '08, or when you won the election in '08,
Yes.
what position did Kelvin Walton have at that time?
Kelvin Walton, I believe, was the acting director of purchasing when I was elected, and I came on in January 1st, 2009. So at that time, he was the acting director of purchasing.
Did you have to make a decision about whether to appoint someone else or to make him permanent director?
I had to make that decision.
And what decision did you make?
I ultimately made the decision to appoint Kelvin Walton as the director of purchasing.
When you became the CEO, did you, in terms of the delegation, did you delegate more authority to the P&C director than the previous administration had as it related to hire or recommending vendors?
As to what the previous administration did and what he did relative to the previous administration.
Your Honor, it shows that Mr. Ellis, choosing not to try to bring power to himself, but delegated others that he thought were responsible and professional to handle the matter. So it shows him pushing power away rather than bringing it in, and that he made a decision to do that and change the prior.
I understand what your response is, sustained.
Did Mr. Walton get a pay raise when you made him the permanent director?
Objection, relevance as to whether or not Mr. Walton had a pay raise. What's that have to do with anything?
Well, I think it has to do with, it shows the amount of trust for doing the.
I understand, sustained.
When you, and when was it that you made Mr. Walton the permanent director?
I can't recall the exact date, but it would have been, I believe, in the first half of 2009.
And Mr. Walton served as your director of P&C until 2013?
Well, yes, yes, and he was the director until he was put on administrative leave, and perhaps his title was still director. I don't know.
Now, when Mr. Walton was serving as your director of P&C, were you aware that he had asked vendors for cash? Vendors who were doing business with DeKalb County, that he had asked vendors for cash? Absolutely
not. I was not aware of that.
If you had known that, what action would you have taken?
Well,
If he's not aware of it, what action he would or wouldn't have taken has nothing to do with this. Mr. Walton's not on trial.
Sustained.
Were you aware that while Mr. Walton was your director of P&C, that he had obtained free services from a vendor who was doing business from DeKalb County and did not pay for those services?
I was absolutely not aware of that.
First of all, I'm going to object as to relevance, and I don't know if counsel is characterizing the evidence as it's come out appropriately. It sounds like a little sleight of hand, but I'm going to object as to relevance. Again, asking him about what he knew Kelvin Walton was doing. He's not charged with doing these things with Kelvin Walton. Kelvin Walton's not charged with doing these things. And so we're, again,
It goes to the relationship that the two men had, which is keeping the case.
Overrule the objection on that issue. Go ahead.
Were you aware of that, sir?
I was absolutely not aware of that.
Were you aware, Mr. Ellis, that your director of P&C went into the special purpose grand jury in May of 2012 and raised his right hand and took an oath and perjured himself before the special purpose grand jury?
I was absolutely not aware of that.
This is a fairly convenient time to break.
Ladies and gentlemen, we're going to go ahead and take our lunch break. I'm going to ask you all to be back at 1:30. Item 7A, please remember my instructions not to talk about the case or allow anyone to talk to you about the case. Continue to avoid any media coverage of the case. See you all at 1:30. Thank you. Ladies and gentlemen, court is still in session. Please be quiet. Is there anything we need to address?
I need to put something on the record at some point. Your Honor, when Ms. Ellis was on the stand, she testified as to our client's reputation in the legal community as she knew him prior to their marriage. After that, I was attempting to go.
Hold on. Just step outside just a minute while he's addressing her testimony.
I'm sorry, I thought.
You step outside just, it's okay? I'll shut up.
After that, Your Honor, I attempted to go into her knowledge of his reputation in other communities other than the legal community, such as her knowledge of her reputation in the family, which is admissible under United States versus John 309 F. 3rd 298, the 5th Circuit 2002. In that case, the witness was allowed to testify that the defendant was a good parent and was willing to do whatever he needs to be done for the children. The federal courts held, which we now follow, in character evidence, that this evidence was not only admissible, but required the lower court to instruct the jury that this evidence was admissible and relevant and should be considered by them in deciding whether reasonable doubt exists in the defendant's guilt. Furthermore, I was prohibited from going into the witness's knowledge of our client's reputation in the Boy Scouts of America, our client's knowledge, the witness's knowledge of his reputation for truthfulness and veracity and good character in the church community and in the neighborhood community. Your Honor, good character evidence is not only relative, it's substantive evidence, and we were prohibited from going into that evidence, and we would ask the court to reconsider that. By not allowing us to put in character evidence, we've been prohibited from going into our defense, and respectfully, Your Honor, it is fair to not let us go into the defense of character since it is substantive and relevant.
Your Honor, what's interesting is that I feel like I wasn't here when Mr. Morgan was doing a direct examination of Mrs. Ellis. Those weren't the questions he asked, and those were not the responses that he was getting. And so I understand that, you know, it's very fashionable and, you know, very strategic to come in here now and grab a case and say, this case says I can do this, and this is what I was trying to do. But number one, you know, no disrespect to Mr. Morgan, I don't think that's what he was trying to do. And number two, that's absolutely wasn't what was being testified to. Your Honor sustained the objection primarily because the responses were non-responsive to the questions that were being asked. Not once did Mr. Morgan say, let me ask you about the Boy Scouts of America. You know, did he ever, can you tell us about you know, his reputation in that community. Let me ask you about this. Can you tell us about that? Mr. Morgan was asking me broad questions that were somewhere up in the stratosphere, which allowed Mrs. Ellis to basically say whatever she wanted to say. And those responses were not the ones that he was reading into the record. So what I would say is that, you know, I don't think his characterization of what happened is accurate based on what I recall. So.
Your Honor, may I perfect the record as to what I said at the bench?
Yes.
Okay, just at the bench, what my objection was that, you can talk about someone's character as it relates to reputation and opinion, as to honesty and truthfulness, or to a pertinent character trait. And asking about his character in the spiritual community is not a pertinent character trait to this trial, so that was one of my objections. I also stated that he was attempting to nullify the jury by asking those questions, and that was inappropriate. And Mr. James covered everything else. Thank you.
Your Honor, may I respond? I was prohibited from asking the questions because of the court directed me not to go into any more character foundation questions.
No, Mr. Morgan, what I told you was that because the witness was being non-responsive and had repeatedly been non-responsive, that you needed to ask her specific questions, and if you needed to leave her, you would have some leeway to do that. You continued to ask her open-ended questions, and she continued to be non-responsive. In fact, speaking over the state as they were attempting to make an objection before the court had ruled on the objection. So what I directed you to do was to ask very specific questions. But in any event, the record will speak for itself about what questions were asked and what questions were not asked, and I stand on the rulings that I previously made.
All right, and I just want to, again, perfect the record that the court ordered me not to go into any more character questions and go directly to the fact question.
What I ordered you to do was to not ask her questions about his spiritual character and things of that nature, because as a character witness, that is not allowed under the law. So, in any event, the record speaks for itself. I stand on the previous ruling. Is there anything else we need to address?
Nothing from the state, Your Honor.
No, Your Honor.
All right, thank you.